Welcome to Wilmic's Risk Management Information Podcasts. I'm Tom Watson. In this podcast, we will talk about practicing law in the area of bankruptcy. I'm speaking with Mark Bromley. Mark runs a two-lawyer firm in Whitewater. Mark, with the fallout in the economy over the past 9 months or so, we've seen a dramatic increase in the number of bankruptcy filings in Wisconsin. How has that affected this particular area of law?
It's been an interesting development because it has increased the quality of the client base. We're working with more sophisticated, better informed clients than ever before. And in many ways that's made the practice easier because the communication barriers are lower and the ability of the clients to provide the information we require is much greater. On the other hand, it also increases client expectation. These are people who are used to good service and good results being delivered on time. And I think that adds a challenge to the practice. It's made it interesting.
And how do you handle that sort of thing? In other words, the clients are probably better educated, at least more knowledgeable. So how do you deal with that?
They usually come in with background also. In this recent upsurge in the filings, we've found many more clients who have reviewed our website, who've reviewed the extensive bankruptcy information that's available online and in print. And so they start ahead in one way and behind in another. They're ahead in the sense that they've read the material. They're behind in the sense that they've often picked up some inaccurate information that has to be corrected. I don't think it's required any significant change in the interview technique. We have always proceeded with an initial interview followed by giving the client a questionnaire to complete and return, and then reviewed the questionnaire and then prepared the paperwork. And that continues to be a successful way to develop the information we have to have.
So do the problems they bring to you, are they different than what they were, say, 10 years ago, 15 years ago?
The problems have not changed in any qualitative way. We still continue to have a mix of people whose problems are a result of medical issues, gambling issues, credit card problems. But there are more now who are failures of entrepreneurship, where businesses that had been successful for many years have failed. And in those cases, we have a stronger psychological component than we've had in the past, with people struggling very, very hard with problems that are emotional. That the feelings of failure, I think, are uppermost in a lot of these cases.
A law degree doesn't prepare you for that sort of thing.
No, that's not training you get at the law school. Not any law school I know of.
So how do you, that is an additional challenge, it sounds like, than what we saw before.
I got an introduction to that early in my practice with the farm bankruptcy crisis, because that also was a lot of entrepreneurial failure. And so it's always been something that I had experience with, but it is something that you have to work on as you develop your bankruptcy practice, because there is no training for it. You don't have time to go get a counseling degree and a law degree.
I suppose that's even more of a challenge for lawyers who maybe are getting into the area of bankruptcy for the first time or haven't done it for a long time, that these are challenges that they may not be prepared for particularly.
Yeah, the challenge of dealing with the emotional upheaval would probably be familiar to divorce lawyers, but not to people coming at this from a commercial practice.
And that, I guess, leads me to this other issue, which is that I do hear that more lawyers are now jumping into the area of bankruptcy, some in an effort to bring in revenue that they've lost in other areas of practice, such as family law, for example. Are you seeing some new lawyers in this area?
We're seeing new lawyers here partly because lawyers who have had a commercial or business practice are beginning to understand that they have to offer the bankruptcy service as a means of providing full service to their existing clientele. And the barriers to entry in bankruptcy are much higher than they used to be. When I started, you could sit around the bankruptcy court when you went in for hearings and learn a lot. The treatises on it were pretty comprehensible. And now, with the bankruptcy reform, the forms requirements have gotten so much more intricate, so much more difficult, that I think they've substantially raised the barriers to entry for new practitioners.
How, when you say more intricate, more complex, how so, and what should lawyers be looking out for?
The establishment of the means test in the 2005 Bankruptcy Reform Act introduced a lot of complexity into determining whether a given client is eligible to be in Chapter 7. It introduced the concept that a debtor above median income might be required to file a Chapter 13 rather than a Chapter 7, and then established a whole panoply of computations that will determine whether that is the end result of filling out the forms and making the necessary calculations. And there's a good deal of case law developing around that issue that a practitioner needs to be aware of in order to do an accurate job of completing the forms required for a bankruptcy filing.
So in terms of the pitfalls for new lawyers getting into this or lawyers jumping back in who haven't done it in 10 years or so, one of the big pitfalls that they should be aware of is the 2005 changes.
It is the big pitfall, yes, none bigger.
And what's the best way to do? Just go back and read the legislation, or what?
I don't think reading the legislation will cover the topic, because so much of this is now a judicial gloss placed on that legislation. That wasn't supposed to happen, but the best laid plans of Congress also go astray, and that's what happened here. I would hesitate to see anyone dive into this without attending some continuing legal education sessions that are directed at that problem, so that they get a full explanation of where the issues are.
How about finding mentors, networking with other attorneys such as yourself who know this sort of thing? Is that a good idea?
I think it is. I have two people I'm mentoring now who are entering the field and getting up to speed. And I think that if the person to be mentored undertakes the initial work of getting the training and then asks someone to help them with the fine points, that's a good way to go at that.
The fact that some new lawyers are getting involved in the area of bankruptcy, is that a good thing? Is there? I'm assuming there are more filers, so more clients. Do we need more lawyers to be involved in this area to meet that need for representation?
I think that the demand right now exceeds the supply. Yeah, I do think more attorneys are needed in this area.
I'm assuming that means you're seeing pro se parties as well?
We're seeing pro se filings, but we're also seeing people who are frustrated because they're calling attorney after attorney and not being able to fit into the caseload. So there's demand out there for services that just can't be met because there aren't enough attorneys to do it.
How do bankruptcy courts deal with pro se parties? I suppose that's another challenge for the courts.
Pro se filers are expensive for the system in the sense that they require more time, particularly from the trustees, but also from the court system, in trying to get their paperwork right. And a typical pro se meeting is going to last 2 or 3 times as long as a meeting with a represented debtor, and will almost always result in a requirement for additional filings to be made to meet the requirements. And that pro se filing, particularly in the Eastern District, I think is tending to bog the system down.
Do you do trustee work as well?
No.
Okay. For the pro se parties, I assume some of them just plain can't afford a bankruptcy attorney. Is there a solution to this?
The Eastern District offers a bankruptcy help desk in which people who are trying to file pro se can go in and sit down with an attorney and review the problems they're having. I don't know how widely that's offered. It's available in Milwaukee, but in the outlying areas, I think it might be more difficult.
Okay. Talk about the differences between Chapter 7, 11, and 13. I know we could probably be here for hours, but I assume there's some obvious differences that people should be aware of, and that lawyers should be aware of too when they take on this kind of representation.
The easiest way to understand that is to realize that Chapter 7 was the original form of bankruptcy, and it's designed to get people out from under their debts and on with their lives. It's usually about a 3.5-month process in which the system makes no effort to reorganize the debtor's finances. It just gets rid of the unsecured debt and leaves the debtor to deal with the secured debt outside of the bankruptcy process, or, well, through the bankruptcy process, but without much court intervention. The other 3 chapters are all designed to reorganize the finances of a struggling entity, whether it's a family that needs to catch up on payments on a mortgage where they've been behind for a year or so and they need to force the lender to remain in the lending relationship with them while the debtors catch up. It could be a Chapter 11, 12, where you've got either a farm enterprise in a Chapter 12 or a commercial enterprise in Chapter 11 that needs the assistance of the court to keep the creditors at bay while past problems are remedied through future income.
And when lawyers take on this representation, obviously, I would think it's obvious that they need to know the differences and they need to be able to identify what's the best route for their clients to take.
Right. Any attorney taking on this kind of a case should be able to articulate the reasons for the choice, the costs and benefits of that choice, and the challenges that choice presents for the client.
Given all the things we've talked about, you think it's worth it for lawyers to consider doing bankruptcy work if they've never done so in the past? I guess even with some of the pitfalls of maybe not knowing the area as well. You said they should certainly do their homework before they jump in. Assuming they prepare themselves, get the knowledge, is it worth it to take on this kind of work?
Well, I started doing bankruptcy work in 1980, and I'm still doing it. So I'm a biased witness here. But I have found bankruptcy practice to be consistently rewarding financially and psychologically. It's an opportunity to work with a bar of very collegial, supportive people. It's an opportunity to work with a bench that is truly dedicated to the ideals that bankruptcy law represents. And I don't regret my choice a bit, and I don't think others who decided to follow that path would regret it either.
Thank you very much, Mark.
You're welcome.
This has been a Risk Management Information Podcast, a service of Wisconsin Lawyers Mutual Insurance Company. If you need information from Wilmick, you can call 1-800-373-3839 or visit www.wilmick.com.